In Massey, as argued by Mr. Harvey and others, are a couple things. What is the appropriate analytical framework for deciding Second Amendment claims? Does the crime of possession of a firearm by a first offender in Georgia have historical antecedent? Does the Second Amendment render appellant, in this case Massey's, prosecution for the crime of possession of a firearm by a first offender unconstitutional? So we have a distinguishing issue in our case is that we don't have this particular applicability of this particular first offender statute, and that we have the other portion as defined in 1611-131A. So let me make sure I get the right statute. I'm sorry, A and as B, and B. It's a disjunctive statute, so it has several ways that that statute can be interpreted, and this particular section, or who's been convicted of felony by a court of this state or any other state. So that is a distinguishing factor in this particular matter that we have in hand. The issue that was raised by Mr. Harvey is, did the state build a record in the trial court as to why this law doesn't run afoul of the Second Amendment? And but distinguished Massey, unlike the circumstance we have in the case at bar, is that Massey's Second Amendment rights prohibit his prosecution for illegally possessing a firearm, particularly because he's not a convicted felon. So
y'all like the video as y'all come in. This is the afternoon session. Trial set for November 27th.
As distinguished in the argument made by both counsel this morning, whether or not that is, you are then a law-abiding or responsible citizen as a Second Amendment application. And similarly, Mr. Harvey argues that the state has failed to provide proof and to meet his burden in persuasion. I believe the state's brief subsequently covers that particular historical and as well as the...
This is a state case. This is handled by local police.
This law doesn't run afoul of the Second Amendment. I'm also going to take, for the purposes of this particular argument, Defendants 1 and Defendants 2. Mr. Uhalski, do you have anything else you want to supplement, or do you wish to adopt Mr. Harvey's D1? As terms of development, of historical development.
I have nothing to offer, no opinion to share on that, Your Honor.
All right. Because I'm offering you, do you have anything else to show that the historical development of the United States Second Amendment? It appears that Massey would require the state to do some particular historical development of the Second Amendment. I believe your brief does adequately address that. However, that's not evidence. That's just a pleading in this case. Mr. Harvey submitted evidence for this particular point. So if you want to adopt it, that's fine. I don't have any issue with it, but I'll accept it as evidence in this case as to the development of the Second Amendment, along with your brief.
I beg the court's indulgence for just a moment, Your Honor, if that's all right.
Right now, the judge is going through case law to determine whether any of the evidence introduced is barred by law or supported by law.
While you're thinking about that, I'm also looking at Massey, and it appears that Mr. Harvey's reliance or discussion about range and Bruin, the Bruin analysis would require some historical analysis, and it appears that the Eighth Circuit has relied upon the Supreme Court's assurances that gun restriction laws are still viable, and it conducted a fairly extensive required historical Bruin analysis, and that's
Your Honor, if I may, I'm going to ask the court, to the extent that Your Honor is asking us, do we adopt Mr. Harvey's exhibits as sort of the exclusive way of looking at the historical analysis that is or would be required if you get past that first prong?
That's one way to look at it.
So the answer to that is we don't say there's anything wrong with him putting that forward. If Your Honor is saying to us that the state is required to, rather than supply the historical analysis in the pleadings, Your Honor would prefer that we kind of physically put into evidence exhibits of sort of the historical analysis that we have put in our response. I would just want a clarification on that issue, because I don't want to rest here and then not have the historical evidence that the court would like to look at if it's not in the right format. Let's say, is the court requiring that we put into evidence these sort of statutes and these items of historical scholarship that we've referenced?
And looking at Massey, it would appear that would be required to show there's an historical, because you have the burden of proof to prove that. It says the government, because
well, is it the burden of proof or persuasion? I mean, this is going to be from Bruin, and this is the United States Supreme Court. The question is whether historical precedent from before, during, and even after the founding evinces a comparable tradition of regulation, and it assigns the burden of showing the historical analog supporting the regulation. I'm not aware, and I do not understand that to mean that this is an evidentiary hearing wherein we would need to put in like sort of the physical, copies of the statutes and things like that. If the court is of the opinion that that's required, we're happy to provide that and supplement what was presented today with all those things. But I do understand the court.
That's my concern looking at Massey and looking at what the argument in Massey is at this point in time, is that, and that's why Mr. Harvey presented this particular evidence, because it would seem to me that that's what the Supreme Court's probably going to take up in our Supreme Court, as well as the others may take up to determine whether or not there is a constitutional framework in that respect. So that's why I'm saying that it might be helpful to include that in the record.
Would Your Honor permit us an opportunity to supplement the record as described here? And if the court's, I'm sure the court has looked over the pleadings. I'm not going to belabor that. But if the court believes that it is required that we sort of submit these items of historical scholarship and historical and legal, we would ask for an opportunity to supplement the record. I can say that for my part, I was not. It was not my understanding that sort of evidence in the form of actual statutes and these law review articles and these decisions that are provided in the pleadings would be necessary to decide the issue today, Your Honor. Would the court be amenable to that at this time?
Yes, but I don't have a lot of time because you're starting on on Monday, and if you're not, and I need to rule on it so you can present proper argument and presentation of evidence.
How much time would Your Honor be willing to give us to summon all this and provide it? I can tell you we'll do it at the court's pleasure. We'll do it in a hurry, Your Honor.
Yeah, and finishing the citation for Jackson, that's 69 F 4th 495 8th Circuit 2023. And the 8th Circuit, they concluded that in determining the sufficiency of historical evidence to support the 922G1, we conclude the legislature's traditional employment status-based restrictions to disqualify categories of persons from possessing firearms. Whether those actions are best characterized as restrictions on persons who deviated from the legal norms of persons who presented an unacceptable risk of dangerousness, Congress enacted with an historical tradition when enacted 922G1 and the prohibition of possession of firearms by felons. So, it seems to be Mr. Uhelski and Mr. Harvey, they're looking at tandem of Massey and Kuhlman, that in order for this case to be properly reviewed on appeal, that you would probably need to have some evidence to support in the record to support the historical analysis. It's listed in your brief. But as Mr. Harvey was quick to point out, he's the only person that's putting the evidence in at this point in time in the historical development. So, and I believe that, that can also include the statutory and case law development of this particular statute. So you may come up with the same conclusions he's come up with, and with the legislative history as to why we have 16, 11, 131, and 133. I believe your discussion adequately handles it, but there needs to be something that would be admissible or be put into the record. So I'll leave the record open until tomorrow.
The prosecution ain't prepared.
For you all to submit something.
They not
and
prepared.
Then I'll make a final ruling on that issue at that point.
And Judge, I understand what you have just requested in the additional time, but let me object to that. This has been on. This is the third time this case has been on for argument. I've made the same arguments over and over again. The state has simply failed to meet their burden. I think the case law is clear. I object to giving them a second bite at the apple. I think we are in a position for you to rule and or to sever those counts out and or give us a right for interlocutory appeal on those particular counts as well. So I'm going to object to additional time to allow the state to do what they should have done when we were here for hearings the last two times. So just want that on the record.
All right, so noted, sir.
Got a good lawyer.
I'll take that over your objection, sir.
Lawyer got the prosecution on the run.
Okay, thank you, Your Honor. Understood.
And I'm assuming I get time to respond?
Yes, Mr. Harvey. You certainly may. I will come with your arguments, as I am going to rule at the conclusion of tomorrow. I mean, I'm basically ready to rule, I think, at this point in time, but I'll give the state, given the position of the cases that the court has read this morning, and because I want to get this right on appeal and preserve it for appeal correctly, the opportunity to do so. So if you have anything else, you can bring it on Friday, bring it on tomorrow, and we can hear it, okay?
Well, I don't know what else. Because this was our opportunity, and this is our record.
I understand this.
All right.
Okay. All right, thank you. All right.
The judge said he ready to rule. Sound like he gonna rule for the defense. Sound like he gonna rule in the lawyer's favor for some reason. But he said he gonna allow the state to get their shit together. This ain't a federal case, by the way. This is a state case.
Okay, counsels, I'm going to take up one other matter, and then we're going to go lunch, okay?